second edition. And you're wondering why I've given little Shabnamji. Unless the household was kept lively, sense of humor of Ejaz would have been buried 9 fathoms deep, partly in Mayur partly in Noida. I also congratulate the publisher because somehow there's a feeling that in our legal system and the setup, humor which once held forth in fair measure has been lost. It was the KV Vishwanathan who I think beautifully brought out the balance as to how humor should be placed in court. He said, excess of wit is buffoonery, and the lack of it is boorishness. I think that's the right balance to get. Because while sense of humor is very important, it is also important to keep the balance. And that is what makes my talk today a little difficult. Because you will realize that just 2 weeks back, with Mr. Ramchandran and Mr. Gokul was here and Ejaz, the very same venue, the Chief Justice speaking on a very important topic on constitutional law. To follow up, and even if you make a reasonably good speech, I don't want even one of the members of the audience to go back saying that we have actually made a very good stand-up comedy. So that's the tightrope. But then with humor, you forget everything. And Urdu poetry is added to it on an evening like the 16th of December when I say the Supreme Court is closed. I know the High Court is open. And on a Saturday, you've also chosen an ideal time to release the book. But then, in a book released like this, dealing with humor, law, and Urdu poetry, one must also involve all the stakeholders in the process of, litigation. I thought I'll deal with humor in general, and then classify it as repartee in advocacy, and try and see how it pays. A particular incident on how humor misfired in court, published instances. Deal with also humor in prose, in judgment writing. And then even bring in humor between the bar and the bench out of court, outside the legal arena. Humor between bar and the bench where the bar got the better of the bench. But then, being now part of the bench, also deal with how the bench on a particular incident got the better of the bar. Humor by the junior at the expense of his senior. We can't leave them out. And wrap it up with a couple of instances of, good humor where clients got the better of the lawyer. So I think this particular passage from Scalia and Garner in their book, Making Your Case, The Art of Persuading Judges, I think made for very interesting reading. So I'll just praise them. They have a bit of advice. They say that counsel with an easygoing sense of humor break the tension and foster amicable discourse by an unscripted witticism, always gentle and often self-deprecating. They also suggest that the bar displays restrained appreciation for any attempt at humor by the court. But then the next passage is really interesting. Elders with age and stature on their side have a bit of an additional leeway. They can get away with wisecracks which lesser mortals cannot dream of even whispering. Judges have no such inhibitions. After all, the bar is waiting to laugh. If a wit is to be ordained from the bench, the problem is when some of us start laughing before the narration is even complete. The But then getting into more serious subject of how repartee in court got virtually, a relief for a client. Somehow, working in Mr. Venugopal's office, though that impressive library had several tomes and treatises, I was always attracted to the jottings and cuttings column of the Madras Law Journal. Some of you chance upon it, please go through them. It's in our Supreme Court Bar Library also, and I hope the pages are not torn. It appears there was a case. Counsel for the devotee was trying to persuade a judge to order the bringing down of a flagstaff of a temple. The allegation was that the jewelry of the deity had been removed and buried under the flagstaff. The opposing counsel, I assume it was Norton because the counsel for the devotee was Sir Subramania Iyer, appearing for the head of the temple, made an emotional appeal and invoked religious injunction and was vehemently resisting it. The judge had almost made up his mind to dismiss the plea, and counsel for the devotee thundered, pointing to the insignia and the motto inscribed behind. My Lord, fiat justitia ruet coelum is our motto. If justice is to be done, even if the heavens fall, should justice be denied merely because a flagstaff would fall? The application, it appears, was allowed. But look at the other instance of Humour misfiring. I've read this before, but Scalia and Garner also mentioned this. An ill-timed and uncouth wit can be disastrous. In the well-known case, since overruled unfortunately, of Roe v. Wade, when it was argued the first time, known as the abortion case, the two women lawyers for Roe, Sarah Beddington and Linda Coffey, had concluded for the petitioner. The Assistant Attorney General for Texas, and I remember seeing his name as one folly. Actually, it should have been F-O-L-L-Y. It was F-O-L-E-Y. He unfortunately, he thought he was, cracking a joke. He opened his arguments thus: Mr. Chief Justice, and may it please the court. It's an old joke, but when a man argues against two beautiful ladies like this, they are going to have the last word. The authors write that no one laughed, and that the onlookers said that during an embarrassing silence, Chief Justice Warrenberger scowled at the advocate. This is where the balance between excess of wit being buffoonery and the lack of it being boorishness. But humor in written prose makes for fascinating reading. It can actually, liven you up. The best passage, there have been quite a few, but I have come across, which not only had a flourish of English language, but a lot of humor, but it conceptualized the entire law of the doctrine of bias in two sentences by Lord Denning, one of my favorites. Many, including yours truly, try to get him. In Metropolitan Properties versus Lannan, the whole thing was summarized by saying, if a judge is biased, he cannot sit. And if he does sit, his order cannot stand. See how beautiful that. The whole thing is there. Doctrine of bias, what happens to the order. Equally interesting was the passage of Lord Bridge of Harwich pronouncing his judgment on the last day of retirement. And as you know, in England, before the Constitutional Reform Act, the appointees retire at 75, and now they retire at 70. They were very cut up, not because of the retirement, but so he put it in his judgment in Huxley Electronics versus Forsyth. My lords, since the populist image of the geriatric judge, out of touch with the real world, is now reflected in the statutory presumption of judicial incompetence at the age of 75. This is the last time I shall speak judicially in your lordship's house. I am happy that the occasion is one when I can agree with your lordships, still in the prime of judicial life, who demonstrate so convincingly that common sense and common law here go hand in hand. So much for happenings in court. So there have been instances reported in annual reports and souvenirs of the district bar where excellent humor has happened. And this one is from the Coimbatore Bar Association, my parent bar and my native place. Humor was, this is what I reckon, certainly not the monopoly of the higher echelons of the judicial setup. Few of the district judges of yesteryears were famous for their repartee. You cannot blame the current ones. The docket explosion may have imploded their sense of humor. This one is from Coimbatore. Leading members of the bar played cricket, tennis, and golf. There was a tradition to organize annual tennis matches between the judges and the lawyers. It is also done by our bar. And I am sure that lawyers must be kicking the ball beyond the boundary when the judge bats. But this was done with the, that's what they say when the great Maharaja of Indore used to bat. But this is a really good one which I found. During one such adventure, one judge, keen to show off his fitness, quite ambitiously went for a non existent overhead smash in a tennis match. Alas, he lost his balance and fell flat. The president of the Bar Association, Adish, is here. He would do this. Was suffocated with guilt and he rushed to the playing arena, got closer to the fallen warrior. You should have only asked him, "Are you all right?" But in that excitement, and he ended up asking in all earnestness, "Is your honor injured?" Fact came the reply, "Most certainly not. My knee may have been." Next is sarcasm in advocacy. Say sarcasm is sometimes